my name is Sonya Madison, and welcome to Law Unfiltered, where I talk about current events and some of the legal implications. Today, the United States Senate approved and confirmed Judge Gorsuch to the United States Supreme Court, and they did it in a very political and often not used way. So as you guys know, under the Constitution, the President appoints and the Senate advises and consents to the appointment as it pertains to the Supreme Court nomination. Well, in this particular case, there's a Senate rule that says, well, you can't proceed on to vote on a nominee, particularly when it comes to the Supreme Court, unless you have 3/5 vote to go past the debate stage. Well, in this instance, they didn't have the 3/5 vote to go past the debate stage because you had enough Democrats to say, hey, we still want to talk about this nominee. And you also have the option of certain Democrats deciding, I'm going to filibuster to continuously avoid having to make this actual 3/5 vote. But someone can close the filibuster and instantly say, hey, I want to nominate this to go to vote. But you again have to have the 3/5. So because they didn't have the 3/5, they decided, well, hey, I'm going to argue that we really don't even need the 3/5 because under the Constitution, we're only to advise and consent. And so a majority would be sufficient to proceed to vote on this nominee. Well, this isn't the first time the Senate has used what's called this nuclear option to avoid having the 3/5 vote to move past the debate stage. Back in 2013, when it was other judicial nominations, but not to the level of Supreme Court, they decided, hey, we only need a majority based on the language of the Constitution, so why don't we cut out this 3/5 requirement to move past the debate, and thereby avoiding filibusters and other attempts to avoid debating or voting on this nominee. Well, it passed, and from then on, the rule became for judicial nominations that did not rise to the level of the Supreme Court, you only needed a majority to move on to actual votes. Well, in this particular instance, they decided, hey, I want to include the Supreme Court nominee. And the Republicans said, I want to have this point of order that only under the Constitution do we need a majority vote, and it passed, and thereby only a majority was needed to advise and consent as to this nominee. So what does this mean going forward? Well, beyond the fact that it's going to stop a long or prolonged debate on what people may decide as two important issues that need to be further discussed, this could also change the way they do other decisions as it relates to the Senate. I mean, if you have the option to overthrow rules that are probably there for a reason to make sure both sides are heard, as well as to make sure bills and legislations and nominees and etc. have the appropriate language to ensure all sides have been heard, then when you stop that immediately, you're going to have a lot of one-sided decisions. And I think that's very harmful going forward. But on the other hand, we do need to have a 9-justice Supreme Court. And if this were to continue to drag on, that could affect decisions going forward. But let me know what you guys think. Let me know if you feel like this was a good move or if you feel like we're setting a bad precedent as we continue during this process. Thanks so much for listening, and I will catch you next time on Law Unfiltered.